Okay, let's begin. So, good afternoon all, and welcome to this Law and Marxism book series event hosted by the Centre for Law and Society in a Global Context. My name is Tanzil Chowdhury, and I'm one of the directors of the centre. And we are a multi and interdisciplinary research centre who examines the global dimensions of law and society. So our Law and Marxism book series is a forum featuring the work of the many exciting scholars researching and writing within the Marxist tradition from around the world. And we explore recently published books and within this tradition and in conversation with the authors and other scholars from across the humanities and social sciences. And our previous authors have included Tariq Kochi, Mayapal, Dina Zuvala and Dimitrios Kivotidis. And you can actually watch recordings of all of our previous discussions here. I'm just going to post a link in the chat. So hopefully you'll have received it. So we're delighted to be joined today by Dr. Zoe Adams, who will be discussing her latest book, A Legal Concept of Work. Zoe is an affiliated lecturer in law, admissions tutor and fellow in law at King's College, Cambridge, where she was previously a junior research fellow. Zoe lectures on labour law and the economics of law and regulation. Her previous book, Labour and the Wage, A Critical Perspective, was published in 2020 by Oxford University Press. And she has written for several publications, including the Industrial Law Journal, European Labour Law Journal, and the Journal of Law and Political Economy. And if I've understood correctly, Zoe is currently working on her third monograph that looks at the relationship between law and power. We're also delighted to be joined by Dr. Robert Knox, our respondent for today, and the previous speaker for our Law Marxism speaker series. Rob has published extensively on law, race, and Marxism, and in particular on the ideas of the leading Marxist jurisprudential thinker, Yevgeny Pashikanis. He was recently the co-editor of a book, Aesthetics and Counter-Aesthetics of International Justice, with Dr. Christine Schwebel-Patel, another participant in our series. And one of his most recent papers included On International Law and Gaza, Critical Reflections for the London Review of International Law. He's a member of the editorial boards of Historical Materialism, London Review of International Law and Legal Form, among other titles. Okay, so enough from me. The format for today's talk will begin with Zoe discussing the key claims of a book for about 15 to 20 minutes. And then Rob and Zoe will then have a kind of back and forth discussion between them. And then if we've got time, we'll open it up to questions to the floor. If you do want to ask a question, I ask that you raise your hand using the raise your hand function at the end of the discussion. I'll remind all participants of that later. But over to you, Zoe.
Thanks so much. Yeah, and thank you for arranging this event. And thanks very much to Rob as well for agreeing to act as a discussant. I want the majority of the time today to be made up of a conversational sort of Q&A between Rob and I. But in order to frame the conversation, it's worth explaining a bit more about the background to the book, what I tried to achieve with it, and also how it fits within the framework of my broader approach to labour law. So for those of you not familiar with my work, this is an approach to labour law that deviates quite considerably from what has become the mainstream of labour law scholarship in the UK, a field of study that has become increasingly abstracted from the political project from which it initially developed, and has also become far removed from the theory and method of Marxism, which had once inspired and shaped its development. So in contrast with the academic mainstream, which has taken on an increasingly liberal orientation over the last 20 years, not only is my approach rooted in a broad and diverse tradition of critical legal scholarship that is highly sensitive to the role of the law in constituting and legitimizing power relations, it is more specifically rooted in a subset of that tradition, which I tend to describe as radical. Now, the distinctiveness of radical legal scholarship, I believe, is its explicitly and overtly political orientation. That is, it sees legal scholarly work as an overtly political act, embracing legal analysis and critique as an opportunity to support struggles for structural transformation. This it does by furthering understandings of the law's relationship with capitalist social relations, the role it plays in supporting or undermining conditions for radical struggle, and in constituting and legitimizing the power relations in the context of which they are forged. This radical orientation immediately stands my approach apart from that of the mainstream, because it means, for example, I'm much less concerned with labour law's impact on workers' immediate interests in decent living and working conditions, for example, as an end in itself. And I'm much more concerned with its impact on the conditions for struggle, and more broadly, on the longer term political project of overthrowing capitalism. So while I do pay attention to how labour law impacts on workers' living and working conditions, how it impacts on values such as privacy and autonomy, etc., I only really do so from the perspective of how, in doing this, it might further or undermine struggles for structural change. To give a concrete example of how my approach differs from that which is common in traditional labour law scholarship, we can contrast my reaction to the 2021 Supreme Court decision in Uber versus Aslam to that of the majority of labour law scholars in the UK. The latter saw this decision, which decided that Uber drivers met the legal definition of a worker and so qualified for minimum wage and working time protection, as a legal victory for workers because, properly enforced and observed, it would mean that many workers in the gig economy were likely to have access to a range of rights from which they might immediately benefit. While some were concerned that companies like Uber might ignore the judgment, they nonetheless praised the decision as a clear success, at least in principle, for workers. I, by contrast, was less convinced. In particular, I was highly concerned with the reasoning the courts deployed in order to reach their conclusion. The fact that the court endorsed a highly abstract understanding of the causes of worker exploitation in the gig economy that obscured its structural origins, and how it contributed to a narrative of exceptionalism that served to isolate the gig economy from more traditional working relations. I was concerned how this reasoning idealized labour law as an adequate solution to exploitation, attributing such exploitation to the unlawful actions of evil or immoral employers, that obscured how such actions are shaped by the structural context in which they exist. I was also concerned with the way the court framed the origins of employer power, attributing that power to the structure of the contract by which workers are hired rather than the broader context in which that contract comes to be. While recognising the potential advantages of the judgment to the claimants and workers in the gig economy, and even the greater flexibility the judgment might provide when it comes to securing favourable legal outcomes to other labour market groups in the future, I was highly concerned that the judgment had simply helped reinforce and legitimise a worldview that was not conducive to radical struggle, which risked overemphasising the advantages to workers of legally enforceable rights, while potentially prioritising the narrow role that trade unions can play in assisting workers to enforce their legal rights, over the much broader and, in my view, more important role they have to play in helping develop collective political capacities and cultivating a broad class-based political consciousness. It is this distinctive approach to labour law that both inspired and has been refined in light of the legal concept of work, which we are here to discuss today. Despite appearances, this book is not a mere exploration of a legal concept, an attempt to set out a series of proposals for how to improve labour law, given the concept's centrality to labour law protections. Rather, the book represents a political intervention into debates about labour law's emancipatory potential and an attempt to improve understandings of the limits of labour law by contributing to our appreciation of the way in which law and legal concepts shape the social reality of capitalism, the power dynamics that influence opportunities for organisation and resistance, and as a result might further or undermine the longer-term pursuit of structural transformation. Now, in order to understand how this book and my approach to labour law came to be, it's worth me exploring in a bit more depth its background and origins. So some of you may already be aware, and as Tanzel mentioned at the beginning, that this is my second monograph and was published 4 years after I completed my PhD and 2 years after my first monograph building on that PhD was published. Now, my PhD was called A Social Ontology of the Wage, and my book, Labour and the Wage, A Critical Perspective. That book reflected, in a highly embryonic form, the approach to labour law I have since developed, focusing as it did on the implications of the law's relationship with capitalist social relations when it comes to its socio-economic effects and emancipatory potential. The thesis and the resulting monograph was very much a response to my frustration with labour law scholarship tendency to valorize labour law, to assume that it is an adequate solution to exploitation and its associated problems, while treating labour law as a mere instrument that can be harnessed to advance any political objective. Foregrounding law's constitutive role in capitalism, by which I mean the immanence of law as a particular form of power relation within the framework of capitalist social relations, I wanted to show how this relationship finds expression in distinctive legal concepts, and so how legal concepts themselves shape social reality while simultaneously reflecting and reinforcing the law's relationship to the social reality of capitalism. Consistently with these premises, that book traced the development of the legal concept of the wage from the 14th century to the present day, focusing mostly on regulation of the wage in the broad sense of workers' subsistence in the framework of a capitalist society. This work helped reveal the limitations of the legal concept of the wage as a means through which to regulate workers' access to subsistence, while also showing how the law had developed alternative concepts, such as remuneration, that helped to mediate some of these limitations, albeit within the limits set by capitalist society. Now, one of the main criticisms that I had of that first book, which was shared by certain reviewers as well, was that the book did not make explicit the role of the class struggle, or struggle and conflict, in mediating the particular implications of the law's relationship with capitalism for concrete legal and social development. It was, in a sense, excessively functionalist and failed to distinguish between what I understand as the necessary elements of law's relationship with capitalism, those features of the legal form that are fundamental to the law's essence, and the historically contingent ways in which they come to be institutionalized, where it is that contingent institutionalization which ultimately explains the precise power dynamics that prevail in a given society at a given time, and so which more immediately shape the contours and orientation of specific struggles. Now, between my first and my second book, I had become increasingly frustrated by the lack of discussion in labour law literature of strategy. And I'm using this term very much in the way that Rob himself used the term in his great article, Strategy and Tactics. I'm not thinking merely about how do we actually bring about legal change deemed immediately favourable to workers, but how do we engage with law in ways that are conducive to our longer term objective of structural transformation while we endeavour to do so. This is a perspective that requires that we take seriously not only what legal changes might contribute to building collective political capacities or fostering solidarity, but also that we take seriously the fact that merely engaging with law and legal institutions to do this may actually obstruct the struggle for structural change, because law is an integral part of that which we are seeking to transcend. But the legal concept of work was also a response to the fact that through my research for labour and the wage, I had realised that it wasn't just how the legal system conceptualises work as subsistence that was significant for labour law's implications, but also how it conceptualises that for which the wage is paid, labour power. It is only in capitalism that providing labour power to others becomes a condition of existence, and thus of wages. And yet, different legal concepts and understandings of what counts as the work for which wages are paid abound historically. I'm thinking here of broader and narrow understandings of service, as well as different concepts such as labour and work. But I had also realized at this time how we conceptualize work is inherently racialized and gendered, giving important insights into the relationship between not just law and capitalist class relations, but its gendered and racialized ones as well. The concept is both influenced by the structure and logic of the capitalist system and the way this finds expression in the legal form, as well as the cultural assumptions which are shaped by that logic and the concrete way in which production and reproduction comes to be organized at a given time. Now, in part 2 of the book, I explore these themes from the perspective of the question of who counts as someone performing work for the purposes of labour law's personal scope, what counts as work for the purposes of working time regulation, what counts as work for the purposes of understanding the nature and scope of managerial power, and what counts as work in the sense of being something economically valuable, using this as a lens through which to understand the gendered implications of the concept and ultimately of labour law. So another key aim of the legal concept of work was to show how the law's conception of work and the implications of that conception were influenced by the different functions which that work performs within the framework of capitalism. I thus explore work from multiple perspectives. First, from the perspective of labour that produces commodities for sale, whether they be material or intellectual commodities, labour that functions to support the process of social reproduction, such as medical labour or educational labour, and labour that facilitates the function of realisation or exchange. Now, each chapter in part 3 of the book thus focused on a particular category of work and sought to show some of the tensions and contradictions that exist as a result of the law's conception of work in that particular industry or sector, relating this to the nature of that work's socioeconomic function. So part 3 provided a series of case studies, including a case study on creative work, a detailed historical analysis of the law conception of the work of authors of fiction, of medical work or the work of doctors, of the work of academics, which consisted of a case study, including empirical research into the perceptions about work of academics at the University of Cambridge, and then a case study into the work of shop assistants. In each case, I situated the discussion in a detailed analysis of the function of the labour in question within the framework of the capitalist system, to show how the limits and nature of the law's conception of work is influenced by the specific tensions or contradictions that arise given the function of that work in capitalism, and how this might have changed over time. In my concluding chapter, I tried to distinguish my strategic approach to labour law by not merely outlining a list of possible reforms that might be beneficial to workers, whether in general or in specific sectors, but also by taking seriously what my theoretical analysis of the law's relationship with capitalism implied about how, in practice, we might want to seek to bring such reforms into being. I thus suggest that while thinking about what legal changes might be useful or necessary, not only should such questions always be addressed from the perspective not of workers' immediate interests and preferences, but their longer-term interest in furthering the struggle for structural transformation, but also that we need to think carefully about how we attempt to do so and how we interact with the law, whether it be legal institutional actors and processes or legal arguments, because building a critical orientation to the law itself must always be seen as an important component of radical struggle. Now, my ideas about strategy and the role of labour law in political struggle have developed considerably since the publication of the book, and I have begun to devote my attention increasingly to how we might rethink labour law's role in political struggle and how this might influence both what sorts of reforms we prioritise and how we engage with law and the legal system in practice. I have thus since published a number of articles which focus more explicitly on questions of strategy from the perspective of the strategies adopted by unions, such as the IWGB, for example, by social actors more generally, but also by legal scholars. Now, the importance of addressing this latter question, namely how we conceptualize the role of legal scholarship in radical struggle, is one that appears particularly important to me in the present conjuncture, given the role that many more traditional labour lawyers have assumed for themselves in commenting in publicly accessible media on legal judgments and legal developments, and in offering their advice to political actors keen to embrace labour law as a mechanism for social change. Very often, however well-intentioned these interventions are, they risk doing more harm than good, because they tend to offer up labour law as an adequate and valid solution to problems facing workers, to idealise the law, and actively reinforce an ideology in the context of which the relevance of structures is downplayed, and the value of individualistic and legalistic solutions overemphasised. As I further develop my approach to labour law and continue to produce radical legal analysis, I thus hope to help educate not only social actors seeking to navigate their own legal institutional interactions, but also legal and labour law academics, drawing their attention to some of the risks and pitfalls inherent in certain approaches to legal scholarship, and encouraging them to think less about immediate short-term gains for workers and particular groups, and more in terms of the political implications of those gains for the longer-term political struggle to which the labour law discipline has historically, but sadly not so much in recent years, purported to be committed. Now, I realise that was a very much a whistle-stop tour through the book, and those of you who haven't read it may not have grasped everything that I've tried to do with the book. But hopefully we can now penetrate a little bit deeper as I pass across to Rob to lead the rest of the discussion.
Sorry about that. I mean, hopefully not lead. We'll co-lead. We'll negotiate it. So thanks, Zoe. That was, I think, really useful, really comprehensive, and like a good showcase, I think, of like a lot of the strengths of the book, although there are more beyond that, and there are things that we can talk about. So we kind of just decided, everyone else, that we would have this kind of like sort of back and forth. I ask questions, there's a response, but we have some kind of conversation at the same time, and then hopefully you guys can jump in as and when you have something to say. So I think the first thing I want to ask, and this is just to tease something out, Zoe, a little bit, is that one of the things that you said early on is that in some sense, contemporary labor lawyers have departed from the kind of original or founding project of labor law. And I guess I wanted to ask you two questions about that, which I think might give us a good space to then explore a little bit more. So the first is like, what do you think that project was like? And as a, obviously it's a non-liberal project, I think is how you would describe it. But what do you think that project was? And then secondly, how do you think that we've gotten to where we are today? Like, what are the kind of factors that have reshaped people's understanding and I think practice of labor law in this way?
Thanks, Rob. Yeah, so I'm really grateful for these questions, actually. So, I don't want to overemphasize the radicalism of the labor law discipline, because at the end of the day, it is a legal discipline. But at the same time, it was one that was very much born from the socialist project, and it has its origins in the project in Weimar Germany, in the struggles in the late 19th century in this country, all of which very much were struggles against capitalism. Now, a lot of the literature that came out, say, in the UK throughout the welfare state period and beyond, was perhaps not so explicitly oriented towards overcoming capitalism, but it still retained that embeddedness in a broad socialist project and this a very, very particular understanding of the limits of law. And in particular, the limits of law as a means through which to seek permanent and real gains for workers, and its risks as a strategy on a longer term horizon. And that has really been lost. I think you would once have said very much that it was a discipline firmly rooted in left-wing politics, rooted to the early ideology of the Labour Party, or the ideology of the early Labour Party and the trade union movement. And that is very much not the case today. I think it would be a real mistake to think just because you're a Labour lawyer, you are necessarily socialist or left-wing. And actually, given the direction that labor law has gone, which is very much focused on legally enforceable rights, you might say that actually labor lawyers are of their nature not all that left-wing anymore. But in terms of where have we got to, I think, and why, I think a sympathetic reading of these developments is a resort to pragmatism in the face of perceived crisis. So I think the rise of neoliberalism seemed to be perceived as an existential threat to labor law, because all of sorry. Anyway, so in the I would say in the sort of 50s, 60s, 70s, labor law was accepted as a legitimate and necessary component of the capitalist system. And so labor lawyers may have disagreed with how it was used and its effects and the right approach to it, but its very existence and legitimacy wasn't questioned directly. Whereas neoliberalism sought to basically make labor law seem as completely unnecessary, and not just unnecessarily, positively harmful. And I think that led many labor lawyers to adopt two different approaches. One was very much to say, well, okay, we agree with you. Let's pretend we agree with you for a second, and everything should be about how to make the market more competitive. But labor law can help us do that. So they sort of adopted this approach whereby labour law became a means to contribute to a neoliberal project, although they didn't conceive it, even if that wasn't their political intentions, in the sense of reinforcing the allocation to markets of major decisions. And it was all about sort of subtly tinkering at the edges to qualify exactly what we mean by efficiency, but not really challenging the idea that it's all about maximising a very, very narrow understanding of that efficiency. And then the other resort, the other change we see is, oh gosh, we can no longer justify rooting labour law in a class political project because neoliberalism says classes don't exist. So what do? Well, we ground it in a universal system of values. And so you have so-called philosophical approaches to labour law grounded in values of human dignity, autonomy, and it basically becomes almost like a way into a human rightsification of labour law because it adopts the same framework. Well, as I'm sure many people attending today, and I know Rob would probably agree with, human rights is very much the flip side of neoliberalism in the sense that as a movement, it has helped legitimize neoliberalism, but also in the sense that it expresses a ideology and worldview and subjectivity that is very much the same one that inspires and is embedded in neoliberalism. And it's almost its flip side. And so what you have today is a large number of labour lawyers arguing in defence of these labour law as a means through which to reinforce individual autonomy, to advance equality, to protect human dignity, not realising the role that these values actually play in reinforcing and legitimising not just capitalism, but its neoliberal instantiation. And so a charitable answer to your question would be that I think a lot of labour lawyers see this as a necessary way to ensure that we don't lose out on labour law entirely. So at the end of the day, even you and I, Rob, would probably agree that we do need some way of protecting workers. We do need some protection for workers' subsistence. And I think they see that as, well, the alternative is so much worse. Let's just concede the longer term for now and do what we can for workers in the present. But I think that's a misguided approach, and it's not so much pragmatism, because it isn't pragmatic, because pragmatism does imply that you've still got your mind on the ultimate goal. It's almost abandoning that goal, and it's an approach of, well, hopelessness and helplessness, really. So that's how I understand it.
Thank you. I mean, that's really helpful. I mean, now the question, I don't know what to do now. There's a couple of things I'd like to put to you, but they're not really questions. They're just kind of observations. And I don't want to pretend that I'm asking a question when I'm really giving a comment. But so I think if it's okay, I just want to make a couple of comments. Some some fully agreeing, some just I'm gonna like push back a little bit and see if we can open it up a little bit. So one thing I really liked about what you just said is this idea of like the reinforcement essentially of like an abstract universal subject as coming to the heart of labor law in this way, which is like reflective of a kind of neoliberal political ideological project. I think another thing it's maybe worth saying is that the other thing that I think that labor lawyers have accepted much more is if you like the separation of the political and the economic, or the separation of the political and the industrial, right? Because in the period, even in the period of the welfare state, there's at least some understanding that industrial action is not like wholly divorced from politics or political action. You have solidarity action, and we have a kind of blurry line about like, well, is this actually an action in defense of your workplace, or is it an action about an act of parliament? Like, and it seems like the thing that happens in neoliberalism is increasingly to shut down the circumstances in which a strike and industrial action will be immunized into just being the narrowest economic corporate interests possible. And that wider action is out, post Thatcher becomes out with the scope of what industrial action can do. And it kind of seems to me like labor lawyers have accepted that, like, is as part of their defensive strategy. In a way, they almost want to say, no, labor isn't political. This isn't political. It's just about people defending their livelihoods, which is accepting a kind of neoliberal narrative about like it's all about individual maximization, group maximization, but you don't do industrial action for like a political project. Like So in some sense, it seems like labor lawyers have actively contributed to the depoliticization of the union movement from a kind of political movement that might be linked to broader political challenges to one which takes industrial action in narrow circumstances and may do political lobbying, but that's not like now understood as like a core of trade unionism. And I think it's interesting, and maybe a thing that what I think we should talk about is like if we think then about like let's say recent discussions in relation to Gaza or in relation to environmentalism and the absolute idea that those things have nothing to do with industrial action. Like, you're a trade unionist, you might do X, Y, you might have an opinion, but that opinion should not have anything to do with like what you're doing in your industrial action and what labor law says. So it seems like that's an important part of the story that you were telling too.
Can I come back on that, or would
Yeah,
you?
no,
Yeah.
come back, but then I'll chat.
Yeah, so actually, I agree entirely. And I think because the focus of the book was the concept of work, I was very aware that my discussion focused very much on the individual labor law. But I have since done a lot more writing on the trade union movement because, for obvious reasons, that is the bit of labor law that I feel is much more relevant. And I think you're absolutely right. And what I find absolutely remarkable is how, I mean, at the moment, there is a lot more discussion than there was previously about how inadequate our system of regulating trade unions actually is. And none of it questions this separation between the economic and the political. But it isn't just that. It isn't just the no political, in order to benefit from the statutory immunities, the action has to relate to basically terms and conditions of work, and the ban on solidarity action. It's also this narrow instrumental view of what strikes are for. So the legislation constructs trade unions in such a way, firstly, that they exist to advance the very immediate economic interests, not of the working class anymore, but of its members. But also, it is the purpose of industrial action is to secure a resolution to a trade dispute where that dispute effectively amounts to demands for different terms than the employer is willing to grant. But industrial action has so many more potential political functions. And labour lawyers, as you say, in endorsing the legalistic view of what a trade union is, are almost abandoning, they're not even fighting for it. They're not even suggesting that you can understand trade unions in a different way. And so by this, I mean, it's not just solidarity action, it's industrial action as an expression of a class identity. It's also industrial action as a process of learning, of communicating with other workers. Hey, I'm suffering these problems. You are too. Guess what? The cause is the same. That sort of communication, but also building solidaristic bonds, not necessarily by joining in one particular fight to help those workers win those demands, but just in creating networks of solidaristic action. So I think there is so much more to be said about the risks of a legalistic approach to trade unions. And what labour lawyers tend to focus on is, oh, the mechanism for statutory recognition doesn't facilitate recognition where it's atypical workers or in the gig economy, or it's too risky for trade unions to go on strike, when actually they're distractions from the real issue. And the more you focus on the distractions, the more you effectively legitimize the fundamental things going on. So sorry, you wanted to make another point, Rob.
Well, now what I'm going to say, so I think you actually agree with this, but I'm dramatizing it for the audience to have a little bit more drama. So I think it's interesting when you talk about the origins of the socialist movement and its relationship to the abolition of capitalism, because obviously that is also kind of contested. You mentioned Weimar Germany, but arguably Weimar Germany, the Social Democrats have their splits, they have their positions. They start off as Marxists, and where they end up is not much like that. And certainly it seems to me that in the Weimar period, their aim is much more they're in principle, right up until the Nazis, they had this idea that maybe we'll eventually not have capitalism. But in practice, what it seemed that they were doing was trying to incorporate workers into capitalism in such a way as for them to have their say in production processes or whatever. And similarly, and again, I think I know that you agree with this, like we could arguably say that in the context of Britain and British trade unions and ideas they have about kind of even industrial democracy and things like that. And ultimately, in some ways, what labor law does is to carve out like the space for like, well, this is like legitimate action at work and opposition to the workplace. You can do that and it's fine. But out width is the more radical stuff, and this just doesn't even come into it. So I think, and again, I just think that you agree with this, but it's maybe something we can put on the table a little bit, precisely because like labor law is like a form of appearance of capitalist social relations. Even at its most radical, it has always been doing some kind of incorporation-y style work. And it, so I think one of the habits that you can then get with labor lawyers is a kind of false nostalgia for like 1945 without understanding all of the compromises, exclusions, and the commitment to the British state of 1945 at the same time. That's just an incoherent thought. I'm sorry, but I thought that was an interesting thing to reflect on too.
I think it's actually a really important point, and I do agree with you. And I think I was guilty of this at one point, because as a law student, I was always sort of, I mean, the welfare state period is always spoken about as this golden era. And there are many labor lawyers who see themselves as more radical than they actually are, who almost wish to just recreate what we had, but slightly tweaked to take into account slightly different conditions. But what is most interesting about Weimar Germany, so you're right that they were fiercely Marxist, but they didn't match their Marxist principles with what they were actually doing. And the thing that strikes me most about Weimar Germany is the extent to which, through the Weimar Constitution and just through in the aftermath of the revolution, the Social Democrats sought to do whatever they could to distinguish themselves from communism. And one of the ways in which they did that was to make socialism a juridical project. The moment, and I mean, the Weimar Constitution, it says it all. The moment you do that, you take the approach that you were saying, Rob, of integration, modifying from within rather than transformation. Now, I think a more charitable reading of some of the contributions to that movement, you can see a more dialectical approach where they were trying to transform it from within, but the actions didn't live up to that theory. And once we had Nazi Germany, everybody, it seems, for understandable reasons, the number one priority became not letting that happen again. And one of the defining features, or one of the ways in which Nazi was seen to be distinctive, was its abandonment of liberalism, the rule of law. And so you begin to get the reconstruction of a new form of socialism where liberalism is at its heart. And that is a different type of project than socialism as I think we would understood, as Evgeny Pashikanis would have understood it, as I would say Marx would have understood it, but even in, I think, as they were talking about in, say, 1918 as well. And this is what you see, for those of you familiar with the history of labor law in Germany, in the work of Franz Neumann, Ernest Frankl, then right through Otto Kahn-Freund, who is deemed to be the father of British labor law, rightly or wrongly, is just this profound process of depoliticization that comes about because even when they were skeptical as to the value of individual rights, although that skepticism wasn't as much as I think people make out, they were not skeptical about the value of a state-led political project, which means a law-led political project, which means one that really seeks to recreate capitalism with workers with a bit more power, rather than to rethink what the structure of society can and should be.
Yeah, exactly. And I mean, you'll know it. It's my favorite Rosa Luxemburg quote, which I don't quite know off by heart, so shit. Where it's like, no amount of reformist factory legislation can overcome the basic presupposition that a capitalist owns the product of the worker. It's exactly as you said, which is that labor law cannot overcome on its own terms a set of social relations, which essentially mean that the capitalist has social power to control the labor process and gets what it's at the end of it, which is like that source of power. So another dimension of this, and you mentioned it in the talk, so I'd like to hear you explore it a little bit more, because I think we can then push that a little bit further, is of course that, like, when we go through the history of labor law, labor lawyers, it's white men, right? Like, that is all of these figures. And you mentioned, right, that the construction of work in this way, and this is in the book too, is racialized and gendered. So could you talk a little bit more about that and a little bit more kind of like detail so we get the sense of that? And then I think that will also open us up to ask a second set of questions on this. But I'd love to hear more about that to begin with.
Yeah, so I think it's really important to think about the racial and gendered nature of work from two different perspectives. So my starting point is that capitalist class relations presuppose different forms of power as conditions of their sustainability and reproduction. And one of those is law, a legal form of power relation, but two others are race and gender. And by that I mean it presupposes a relationship of power between, on the one hand, those that perform productive work for the market and those that perform social reproductive labour. And I understand that as a gendered power relation. The reason I refer to it as gendered is because of the way in which that split has been organised around the institution of the family, which is gendered because of the way in which the sex mediates biological reproduction links to social reproduction. But importantly, and I don't think this is as well understood, a racial power relation is also built into the structure of capitalism. And by this, I don't mean the contingent way in which race has come to be understood as skin colour. I mean, there is always an inside and an outside of capitalism, because a precondition for exploitation, understood as an equal exchange in the market, is expropriation. And so you always have a group or set of resources that makes possible the sort of the formal appearance of equality in a labor market that is at the core, and in the market that is at the core of capitalism. Now, because of the way in which capitalism developed, and because it arose around the territorial and jurisdictional boundaries of the state, this inside and outside, as capitalism developed, increasingly became an inside and outside of the state. And those countries in the position of power who started to develop capitalist social relations earlier, who had the resources to expropriate other populations, happened to be white. And so you have that historical process whereby the white came to expropriate the non-white. And that is, as I understand it, that is the fundamental, that's why capitalism is inherently racist. I know there's a lot of debate about this, but in that sense, it is inherently racist. I'm just understanding race through the lens of capitalism, if you know what I mean. But what is really important is that you've got that dynamic, or let's call it a racial power dynamic, but then the particular way in which those processes unfold lend content to that racial power relation. And that is where we get shifting understandings of what counts as white and non-white. And we have hierarchies within those categories as well. And I think that is really important. And I mean, things like skin color became almost like, well, this is the one thing that is associated with those groups that were historically expropriated. And so it becomes a proxy rather than the essence, which is something that obviously we've lost sight of. But from the lens of the legal concept of work, on the one hand, this racial power dynamic is implicit in that concept because work is something that presupposes a particular, basically the exploitative relationship, but not the expropriative one. Work is reserved to those privileged people who actually do get paid a wage in exchange for their labor power and whose relationships are at least formally voluntary. And so in that sense, it both helps to reproduce the racial power dynamic and is racist in and of itself. But also importantly, is this racial power dynamic leads to uneven development. It means that a lot of people that came to the UK as migrants tended to be seen as less valuable. Their labour became to be seen as less valuable, but then they got access to worse skills opportunities. They had greater barriers to organisation, so their labour continued to be cheaper on the labour market, which then reinforced perceptions that it is cheaper and not as good. And so you have the concept of work being forged in the context of a labour market through struggles. So the legal concept of work, as my book explains, really emerged first from when you wanted to regulate the duration of the working day. You needed to understand, when are people working, what is work, and as that concept is forged, it is forged within a labour market which is structured hierarchically on racial as well as class grounds and gendered grounds. And so in the same way as that the legal concept of work comes to express gendered power relations because it reflects the power dynamics of labour markets in which women were very much marginalised, so too does it express racial power dynamics, but in a more contingent sense. And that is why the extent and ways in which its gendered and racial dimensions manifest changes over time. But you can't just say, oh, well, this isn't an intrinsic feature of capitalism. Just because capitalism used to be racist, it used to be gendered, we can create equality now and all is fine and dandy, because the system as of its nature contains within itself racial and gendered power dynamics. What we can perhaps change is perceptions and outcomes and within the framework of that basic inequality, gendered, racial, and class inequality. But you can't change that fundamental nature. And just to slightly deviate from the point, Rob, but that's why gendered and racial struggles are not separate from, they are inherent in and should be organized through class lines. Class is the uniting lens. And I think this is the point that is really misunderstood when you say, well, Marx overemphasized class over race and gender. Well, only because class contains within itself a particular expression of gender and race, which is the relevant one for that type of struggle. Anyway, so hopefully that clarifies a little bit what I was alluding to, although I realize I've just opened the biggest can of worms possible.
There are bigger cans of worms. I mean, I agree a lot with what you said. I just wanted to do a couple of follow-ups and to put some stuff to you. I will start off just by saying, like, I agree with what you said. I don't get there doing the exploitation expropriation thing. I think it's messier than that. But that's a different. I'm only saying that just because I've recently written something saying why I disagree with that. But like but I don't think you need that to do this. But the interesting thing that I wanted to ask you about in this context, and again, I really liked what you said about this. It seems to me, right, that many people, and this links to that kind of nostalgia for 1945, in the labor law community, more broadly on the left, and also in some of the kind of recent writings about stuff like, let's say, about techno-feudalism and the changing work relations, they start off with a normative idea that work means stable, regular work for a regular wage. They think that's the normal form of work under capitalism, right? And that's why they say, oh, we're all turning into serfs now because we don't have autonomy in our jobs. And that's also what people who have a nostalgia for the older moments have. And in a sense, that's because this is the foundational argument and mission of not even just the reformist labor movement, but the kind of classic labor movement, which is like, this is what work is. And what we'll do is reduce hours and increase pay, but this is the basic thing. Now, what I really like with what you're saying, and particularly stuff on race and how I want to push this is, part of the problem here is also that the moment in which that imaginary is formed is a moment in which the countries where that was possible were like had formal empires. This was the pre-decolonization. So there's this idea, I think, and this is like a kind of like, it's a classic Leninist insight, which is that perhaps this, so then there are two things. Firstly, this formal, stable idea of work is not what work under capitalism has looked like in most of the world for most of capitalism's existence. Most capitalisms outside of Europe and America do not necessarily primarily involve work that is regularized. It is what people now try and call informal, but of course it's like, no, but this is like what work has always looked like outside of the capitalist cause. And this has not even characterized what work looks like inside of the cause of capitalism for most of their existence either. So I say this because, and I'm sorry everyone for like me like just making a stupid hand wavy statement, but I wonder if one thing we can think about labor law as we understand it is that it forms in the context of the most explicitly racialized imperialism in existence. It doesn't theorize the material conditions in which essentially the class compromise of the 1940s to the 1970s could come into being. And part of those material conditions, I think, is the open and active subordination on a racial basis of most of the world, which enables you to have like islands of regular work outside of everything else. And then that means that some of the normative model of left-wing labor lawyers and that nostalgia is inadvertently also a racial nostalgia in which the normal work, the normal good old work patterns that are being fought for were dependent upon the very sets of racialized relationships that you were talking about. And I don't know if this is the question. I'll just at the end say, oh, what do you think? But this strikes me as an important thing insofar as it brings again in the constitutive nature of racialization to the labor law project, not just like domestically, but also internationally, in the formation of this idea of the normative and normal ideal of work being a regular, like, now, that doesn't mean I'm like, oh, you've got a regular job, you're racist. But it is like, oh, this model is based on the idea that everyone can have this, and it's not. And I say this because I guess my final closing thought is then it strikes me as important that most labor movements, and certainly conceptions of labor law, are nationalist in orientation. Their basic unit of analysis is the nation state and the nation. And indeed, the conditions of people working in a supply chain to a British company is not necessarily something that British labor lawyers would think concerns them at all. They might be like, well, that's the ILO's job or it's whoever's job. And this just strikes me as an important manifestation of the way that race and racialization play out in the context of labor law. I'm so sorry.
No, and I'm really pleased you mentioned this, because one thing you'll notice that mainly, not unironically, a lot of female labor lawyers have pointed out how everything that women do at home that is unremunerated helped build the welfare state, and the welfare state and beverage and everything was all predicated on this particular understanding of what women can do, and as you say, of them not being able to have the full-time work. And the same awareness doesn't seem to exist in terms of the racial dynamics. And it isn't as simple as say, racial minorities within Britain were not able to access the stable forms of work that were idealized. It's much more insidious than that. It isn't even just that their historical expropriation made possible the economic development that underpinned it. It's that as the welfare state was constructed, we were still taxing colonial, like the colonies and countries like India, and we were then saying, if you come to the UK, you aren't able to access the benefits of the welfare state, but you must pay for it. And there's this insidious racism underpinning it. And then on top of that, the model of work was exclusionary because it was based on lifestyles and customs and culture particular to a particular country. But what I think is really interesting from the perspective of labor lawyers and labor law scholarship is that they seem to not, they idealize it. Even even while being slightly sensitive to it. So it's always a caveat at the end. Oh, of course, the standard employment relationship didn't work for everybody. It was slightly gendered, slightly racialized, but still, it was still this great model that we want to recreate. But it implies that we can fix the gendered and racialized problems of this model when actually, as you say, it is built into its very structure because a presupposition is that other people are doing things outside that framework in order to make it possible. And to your point about that this is the standard employment relationship, when historically and transnationally it is not standard, I think is a really important one, because I feel that labour lawyers have lost sight of the political potential of an understanding of work in which people do have regular, stable employment and a decent income and can sustain a good life outside of work. And the idea that, one, that is sufficient, and two, that it is something that we can create legally and institutionally, rather than, I mean, I would much prefer to think of this almost as an entry point into why we need structural change. Because the moment you start to say, well, in an ideal world, this is what we would have, you have to say, well, why don't we have it? And you realize that those reasons are structural. And once you realize that those reasons are structural, you realize why we need to overcome capitalism. But that, quite logical, I mean, I got through that logical argument in about 10 seconds. That reasoning process just seems to be truncated, or at least not even engaged with in labor law scholarship. So I do think it's really important that you raise that point, Rob.
That's a really really great point. I mean, but I would say that what you've described there, this seems to be a short circuit for a lot of thinking more broadly beyond just labor law. So Zizek, who has many negative qualities, but an argument that he makes is that remember when everyone got obsessed with the Tobin tax and they were like, oh, we can just tax every financial transaction. And Zizek was just like, sorry, if you have the political will and the political power to surveil every financial transaction and you are able to impose yourself upon that, you've already won. Like, why would that wouldn't even be enough? Like, if we had the power to impose even the idea of that, it's like, well, you should do more. Because if you're allowed to do that, then you could do more. Like, you're making a concession in this kind of way. And I think people get short-circuited, like, at that point. So I think we said that we probably got like 5 more minutes, what Fansel was thinking, until we get to like some audience questions and stuff. So I wanted to turn this a little bit then for us to just think about some contemporary developments and some future developments. So just very quickly, I think people might be interested to hear what you think about, very contemporary, the kind of Labour Party's proposals on like labour law reform. It's going to be negative, but I think it's good for people to hear some negative stuff about that, to be honest. If we can briefly talk about that, and then I'm going to ask you for some strategic questions too. But what do you think of the stuff, so the stuff that's come out of Labour?
Oh. So it's interesting because what I was saying about how labour law scholarship has become disconnected from the Labour Party and the Labour movement, I made it very clear that I meant the way the Labour Party originated, because I don't believe we actually have a Labour Party anymore, and I think that is exemplified in the Employment Rights Bill. So I have a number of very legalistic critiques, because at the end of the day, it is clear that they are pandering to business and that they are introducing individual rights which will not be enforceable, that employers can easily get around in an attempt to make it look like what I suspect are going to be fairly not good changes in their pursuit of growth, that all this is in the interests of the workers, when it isn't going to be. They don't care. But more fundamentally than that, there are aspects of the narrative with which I am really concerned, and I'm even more concerned in the way in which it is being endorsed by labour lawyers themselves as they talk about the bill. So, for example, many of you will probably remember that, I think going back to Corbyn, the Labour Party have committed to abolishing 0 hours contracts. The Employment Rights Bill does not do that. Because, and this is what they say, we realise that it works in the interests of students and people with caring responsibilities who need a more flexible approach to work. Well, okay, why aren't we asking the question for people with caring responsibilities and want to study, why is this the only option available to them? Why aren't we thinking about, is there a way to organise care, or can we reconceptualise study in a way that actually either means they don't have a pressure to work at all, or they are able to have the sort of job that people without those needs want, but aren't able to get them? And so it's a narrative in which you present this as, oh, well, this is a natural desire they have. And it may well be that students would have been horrified had they abolished 0 hours contracts, or carers would have been horrified. We've got to understand what are the drivers of those interests, what makes something like that work badly for them, and how can we bring about broader changes? The other issue as well is, I mean, they are tinkering at the edges when it comes to collective labour law, and they are not really thinking about how do we create a society in which trade unions play a much more fundamental role. There is no longer term thinking in terms of what legal changes can we make which might actually empower unions to get more members, and build a stronger foundation that way. They've even abandoned their commitment to introduce sectoral collective bargaining, and instead of doing it in 2 sectors, but it's not going to really be sectoral collective bargaining, without any explanation for, like, oh, because it's really important in those sectors. But if you can do it there, why not do it more broadly? So I am very, very concerned beyond. I mean, I have actually been asked to provide advice to the government on the bill. And obviously, in that context, I offer both sets of critiques, the legalistic ones where there are huge holes in what they're offering up, and the much more political one being that, but I wouldn't even bother correcting it because you should be taking a different approach anyway. But I think it's really, really important to recognise this and contextualise it within the history of the Labour Party and see how that maps on with the history of legal scholarship as well. Because the Labour Party too took a pragmatic approach with neoliberalism, and they basically adopted neoliberalism's basic tenets, but tried to argue that, well, okay, we want fair competition. We want to have to mobilize labor law to support markets, but there has to be an element of rights-based protection. And you also have a shift. You have a pragmatic response to the decline of trade unions. Okay, so trade unions are really weak. In that case, we need individual rights because what else is there? And so you have that narrative. But today, the assumption is that the law has to follow the social reality of modern work, rather than recognizing that law has helped create that social reality, and so it can reshape it. So, I mean, as you can tell, I could rant about this for ages, but I think the most important things are the narrative and the direction of travel, and the fact that the Labour Party has come to see law as a solution to the problems for workers, which is a disaster. And even more troubling is the fact that they've got the trade unions on board.
Great. I think that was very thorough. Excellent. If anyone could hear any noise, the cat is hungry and she is aggressively meowing for food. So I'll ask one kind of, one kind of relatively positive question now, which is, so one of the things that you said, and of course we've both worked on this in common, is to think like, okay, well, insofar as we engage with law in a legal form, we try to foreground the ways in which law can facilitate like the struggle against capitalism without as much as possible undermining that struggle. It's always a dangerous ground. What sort of reforms right now do you think might be effective in that domain? Like what kind of things do you think could be helpful there? More or less realistic. Like obviously I can think of some unrealistic ones.
I think I want to caveat what I'm going to say in the sense that it's not so much that the reforms themselves can be useful, but there are strategies we can take in mobilizing behind certain reforms, which, when we do it in that way, may be useful. So I mean, there are a number of rights that have been sort of notionally bandied around that would be really, really useful and that we should pursue them. Now, I don't think that if we pursue them straightforward as ends in themselves, they would be useful, but I think they actually provide a really important opening. So, for example, the one thing that many of you may have heard of is this so-called right to switch off. And I mean, there are huge holes in this because how would it be enforced? But actually, the moment we start thinking about how does employer power manifest out with the boundaries of formal contractual obligations? This creates an opening through which to problematize the way in which our entire existence is co-opted into the services of capitalism. And so I think, firstly, as an academic, and I'm sure other academics here will be very, very sensitive to this, the idea of a right to switch off is very appealing because for us, our so-called 37-hour week is really 70 hours because we can be accessed at any point. And I do think, and I think from a very practical standpoint, at the end of the day, I don't have much time to engage in union activities. I don't have much time to engage in political activities because all my time is going on work. So I think these basic things actually do have a very practical use, but they also have a really interesting political use. Now, another thing that I think is really important to think about in the realm of thinking about collective organization and things like that is how can we rethink, and maybe this is crossing into the territory of unrealistic reforms, Rob, but to be honest, under this government, I think anything's unrealistic. But think about things like the employer actually has no obligation to compensate you for the fact that the employer basically co-opts all the time that you could be spending on political education and becoming a political being because for the purposes of their own profit making. So there is no obligation, for example, to educate you on how the organization works, on the constraints in which they're operating. There's no obligation on them to provide you with an opportunity to interact with different people. And I actually think there is a scope for very inventive thinking about, for example, one thing I've been playing with is the idea of a right to democracy time. This idea that there has to be a designated time during the working week, which workers are actually positively empowered to do political things, to have trade unions come and talk to them, whether or not they are recognised, and for the employer to actually provide information to the workers from which they can learn. Now, many traditional labour lawyers are going to point out all the holes in enforcement, that employers won't do this, but it is still a really important thing to be thinking about, because if we start talking about how employer power truncates the realization of workers as political and not merely social and economic beings, we can actually start raising a narrative that might actually generate political pressure to make certain concessions. And those concessions will never go as far as we would want them to, but they might be beneficial, and they might be particularly beneficial when embedded in a narrative that makes how insufficient they are quite explicit. And on a slightly broader point in terms of, I mean, I am definitely in favor of shifting thinking when it comes to regulating wages towards one that is much more focused on sector level collective bargaining, and basically in which we move away from this idea, not only that, I mean, in this country, it's even radical to suggest that the wage should approximate costs of living. But I would like to move away even from the idea that there is a cost of living that is fixed, and actually start thinking about how we can facilitate a democratic debate about what we think living standards should be and relate that to what cost of living should be. And so I think there's a lot of scope for exploring ideas in relation to that as well.
That is great. I will just add my little one, which is that I think that anything which can broaden the definition of a trade dispute to take it outside of the more narrow grounds could have a runaway, a multiplier effect insofar as it can give trade unions more political legitimacy. It can kind of explode some of this economic and political stuff. And actually, and in a sense, it doesn't even have to be a reform. I think more creative thinking about the relationship between environmental concerns, trade disputes, health and safety as a space to collectively organize workers, and therefore broaden out their sense of what trade unionism involved could be good. So I think, Hansel, did you say we were gonna open up the questions now, or am I mean, I think you said that.
Yeah, what we'll do is, I mean, first of all, really, really rich and nourishing discussion. I'm going to try my hardest not to take advantage of my chair position because I've got a couple of questions I want to ask. But I want to now open it up to our audience. If you want to ask a question, if you could click the raise your hand icon, and I can call on you. Anybody has any question? Okay, so we have Dr. Hamna.
It's Hamna. It's my academic alias because I have a very common name. So,
okay, no problem.
I asked a question in the chat. It was very early on because it was something that interested me. So I don't know if you could just read that out.
Would you like to read it instead?
Yes,
Is it given it's your case?
Yeah. So I was basically saying that I'm an academic. I started a HR Masters at Leeds in 2018, and I'm now doing an LLM in London that I started in 2024. And basically the Uber v Aslam case in 2018 was very new, and it was drilled into us because you can't really do a HR Masters in this country without doing employment relations. And that case now, in 6 years later, is still a very central part of employment law teaching. Pretty much anywhere. It's very unlikely you'll come across any employment law module that doesn't mention that case. I'm saying this because I agreed with the point that the case did a lot for academia. It gave us a lot to talk about, but it didn't really do anything for actual legal structures, like Dr. Adams was saying. So my question is, or I don't know if it's really a question, I'd be really interested to know, is there anything specific, especially in terms of case law, that led you to this conclusion? Because for me, the reason I agree with it is because I haven't seen this case go beyond academia. It's like a landmark case that's very, very relevant to academia, but then what else is happening, if that makes sense? I know it's a bit confusing, but I don't know if that question makes sense.
Yeah, I mean, Tantal, am I okay to answer?
Yeah, go ahead, please.
Yeah. So, no, that's a good question. I mean, to be honest, my analysis comes from actually analysing what the court said, and I'm analysing how problematic the way they understood things was. Well, if you're asking, like, how do I support my view that it's not particularly significant? Well, the Deliveroo judgment, which was an attempt by Deliveroo couriers to gain statutory recognition that they could only do if they proved that they were workers, was handed down, I think, within weeks of the Uber judgment, and it was referenced. And it was swept aside because, Uber only applies to domestic law, and this case raises issues of international law because it relates to Article 11 of the ECHR. Oh, and also in Uber, there wasn't a substitution clause. There is a substitution clause here, so it's not relevant. So that for me was fairly obvious attempt by the court to, so ironically, narrow the scope of what I thought was already an inherently narrow judgment. And I think if you look at the case law, there has not been a significant change in direction. And there hasn't been a change in direction because they just reached a different legal conclusion on the basis of the same premises. If you read the Uber decision itself, there's a really important passage where they say, they basically, and this is what labour lawyers jump on, in that the purpose of labour law is to compensate for vulnerabilities. And so workers are people who possess those vulnerabilities. Those vulnerabilities come from the subordination and dependence that is inherent in the employment relationship. That finds its expression in control. And then it goes on to say we can see control in the right to control the worker that the employer has by virtue of the contract, which is not where control comes from. Control comes from the basic fact of the employer's position of dominance in a society in which they monopolize the means of production. It pre-exists the contract and enables employers to shape that contract. So you can see in the reasoning, and if you read the reasoning of the cases that are decided regularly on employment status, even when paying lip service to Uber, and even when the outcome is favorable to the worker, because there have been many cases where people in the gig economy have been recognized as workers, they're recognized as workers for the same reason, which means we're not challenging the point that labour law is always going to be under-inclusive, because it always understands power in this abstracted way. So if you think about, control is like this expression of power, and labor law exists to regulate that power, so therefore where control is present, then we've probably got a relationship we want to regulate. But if you understand power in abstraction from the structures that underpin it, you're never going to include everyone.
Thanks for that response.
Thank you. I was going to say thanks.
Any other questions? Otherwise, I'll ask my own. But any other questions from the audience? Okay, maybe whilst people are thinking, Zoe, if I could ask you a question, if that's all right. So I want to talk a little bit about the problem with the legal form and with juridification. Because I mean, and it kind of foregrounds one of the kind of limits of law within as a means for kind of socialist transformation, because for labor to socialize the means of production would necessarily require a or illegal act, by taking over the means of production which are the property of the kind of capitalist class. And so thinking about strategy and tactics, and I'm also kind of thinking about one of the papers that Rob wrote on New Labour, the anti-juridical constitution, New Labour. If juridification is about pulling labour struggles into the orbit of the courts and the courts mediating labour antagonisms, might one suggestion of a reform be less law, right? That what we want to do is not basically apportion more rights per se, because what that potentially does is it pulls again, the courts colonize labour struggles, but actually what we want to argue for is less law, less interference of the legal form into industrial disputes.
So yes and no. I don't believe that the problem is just pulling labour struggles into the courts as one institutional manifestation of the legal form, because it's also about bringing it into the realm of the state. And so when we had the compromise, I can't remember what, sorry, Rob, I can't remember how you framed it in your article, but in that period, yes, labour disputes were mostly kept out of the courts. And the legal framework created space for trade unions to interact in a realm in which they weren't constantly referring to a legal framework and rights in order to understand what they were doing. And that is inherently valuable. And I would agree with you that if I had to choose between two models, a model that provided insulation from rights and the courts is absolutely paramount. But in that period, there wasn't insulation from law completely, and the trade unions were very much dependent on a legal framework. And indeed, the orientation of their struggles was very much shaped by the fact that they had already been integrated into almost the sphere of the state and into a particular way of thinking about struggles in which, as Rob has rightly said, the separation of the political and the economic is implicit. So I agree with you, Tanzil, entirely that actually, if I'm thinking in what I would say is genuinely pragmatically, yes, we want to think about how we can recreate, because it's much more reasonable to do this, how we can think about a framework of industrial action and collective bargaining and organisation, which is less dependent, or at least gives less power to the courts, and which is why the system of immunities as originally conceived was so powerful. But we need to do more than that. And we need to think about autonomy from law in much more fundamental ways. And I think it's really important to recognize that it really isn't as simple as saying, let's have less law. No matter what you do, it's going to have legal consequences. And in order to do anything, you need the law, because the law profoundly shapes the resources and opportunities available to everybody. So we can't just say less law, we're sorted. That's why it's always about creatively using it, and creatively using it to create more space. And it's more space both physically and institutionally, but also ideologically, and that insulation from a particular way of thinking. So, and I'm sure Rob's got his hand up, so I'm going to pass across to Rob, because I think we're probably on the same page more or less here. But my answer to you, Tanzil, is a qualified yes.
Yes, I mean, I think we agree a lot, and specifically, as I say in that anti-juridical constitutionalism piece, as I said a couple of times before, the problem is that that insulation from the law was a legal settlement to begin with. It was because of a set of juridical relations which enabled that to happen. So there wasn't an inside or outside of the law in that context. There were particular like relationships to, as Zoe said, the law and the state, which were also juridical in nature. And that's in part because, look, I think one of the fundamental lessons from Pashkanes is that if law is a mystified form of appearance of capitalist social relations, it's almost voluntarism to think you can opt in and out of it. Like it's just there, you know. So the reason I say this though is that then there's a second point, which is where I would push a little bit, not necessarily push beyond, but I think this is an important rejoinder to this point, is that we also have to avoid falling into the danger of being captured by law ourselves. Because I don't think the question in this context is just like, is it juridified or not? And that can't just be answered within the idea of your relationship to law. The question is also like, well, insofar as something is juridified, how much does that dictate your actions, and what do you do, and how does that affect that? So a very important example of this, and again, like I think Zoe will be aware of this, I've mentioned this in other contexts, like in 1971, where the Conservatives passed the Industrial Relations Act, which is like in kind of a precursor to how like labor law is now, but it was trying to like individualize labor law much more, etc., etc., etc. And it got to a point where like there were some trade unionists who were just refusing to comply with like legal rulings, and the government had to be like, well, are we going to arrest them from contempt of court or not? And they were like, if we arrest them for contempt of court, we'd actually be kind of fucked. Like we would essentially set off a political crisis. And so in part, this wasn't just about the law that being there or not being there. It was also about the relationship of the trade unionists in this context to the law and its consequences, and understanding that we can also at points overinvest law with more power than it has in any given circumstance. Now, the reason I also say this is because one of the things that I think that we need to do when in all walks of legal life, when we're legal academics, people on the left thinking about law, is understand that we can't just answer these questions in the abstract or in the legal field. These are also, I think, organizational questions about, like, a huge part of this essentially is one reason why trade unions are like this is because trade unions have an affiliation to the Labour Party. The Labour Party is a party of the British state and adheres to the law in a very specific way. So you can't have a situation where the Labour Party, as part of a division of labor with trade unions, is like, screw it. Like, this might look illegal, but you're just going to do it anyway. That's what communist parties could and did do historically, which is like they were the political direction to at least certain trade unions in their actions in this kind of way. So in a sense, the perspective of more or less law, which is not unimportant, is still a perspective that centers the action of the state and what the state is doing as the central thing. To me, the question is like, okay, what's the relationship or orientation of the labor movement to that, right? But that is then an organizational question about what does the labor movement do? And I say this because I think, and I might sound a bit all over the place, but another thing I think it's important for us to remember is existing in Britain in 2025, I had to literally check what year it was, you can be forgiven for imagining that trade unions are always the most radical actor in the labor movement. They're not. Historically, trade unions have been often to the right of the labor movement, even to the right of labor parties. They've often been a kind of drag on wanting to do more radical action because trade unions are creatures of capitalism as an institution. That they are, because without capitalism, there wouldn't be trade unions, actually. But like, whatever. So I say this because what this says is the question is not then just more law or less law, and how do we orient it, but also what is the relationship to trade unionism to other political forces, constellations, and organizations, and what are the concrete sets of relationships which then condition that? Because that also affects how it is that a trade union views and relates to the law in particular ways. So, like Zoe, in the abstract, I would be like, I might be like less law, but I also might not. Like there's the old Joan Robinson quote: "The only thing worse than being exploited by capitalism is not being exploited by capitalism." And to be honest, at certain moments, it's like the only thing worse than being enmeshed in a legal form is not being enmeshed in a legal form. And so I think that means that the question then is not just more or less, but it opens up a whole constellation of questions about organization, the state, the relationship between law and politics, the autonomy of like class action as against the state and as against the law. And that then presupposes a sense of more searching and fundamental questions, and also internal battles within the trade union movement about what the trade union movement and what the workers' movement more broadly is for. Okay, too much.
Just one comment on what Rob says, and I think it's really important. Legal academics seem to forget. They seem to associate trade unions as the only organization that represents workers, which means that they are disconnected from the reality of organization. Because if you ask any trade unions, they are constantly involved with other civil society organizations. And the more that we abstract and say trade unions need their special legal regime, whether it's more or less legalistic, we reinforce that separation, which is just this reflection of the separation between the economic and the political. So I agree with Rob, and I also think it's really, really important that, and I'm guilty of this as well, it's all very well and good having this conversation at an academic level and me talking about how to like generate new ideas about how to organize capitalism, but I need to be embedded in what organizations are actually doing and developing those ideas and understanding what's going on the ground in order to, it has to be, I mean, we have to challenge that division of labor as well, I think, is what I'm saying. But anyway, sorry, just jumping in on the end there.
No, thanks for that, Zoe and Rob. Unfortunately, we're going to have to bring things to an end there. I want to thank both of our Zoe as our author and Rob as our respondent, and the kind of really rich discussion that they've had, and also to our audience for patiently listening and asking questions. Apologies that we've not been able to afford more time to ask questions. I've just posted a link again in the chat where you can find previous recordings of our Law and Marxism speaker series, and we'll be also uploading the recording of this discussion. So thank you very much, everyone. Again, thank you to Zoe and Rob, and I hope everyone has a lovely day. Take care.